May please, Your Lordship. Lordship, I'd like to mention item number 9. The LCR was called for. It's just for the possibility of bail. LCR has not yet been received. And I'll take fresh steps on respond number 2, the informant. I'll take fresh steps on respond number 2. I had already served scan copies, but I'll take fresh steps by hard copy on respond number 2. Okay. Item number 9.
Item number 9 is D.K. Bhattacharya and counsel for the appellant submits that he will take fresh steps for service of notice on respond number 2. What is the offense? Okay, the registry shall process the notice and hand it over to Ms. S.H. Boral and APP for service on respond number 2 through the officer in charge of the jurisdictional police station. The officer in charge of the jurisdictional police station shall ensure that the notice is returned after service. The service report is returned to the court prior to the next date of listing. The notice is made returnable on after 6 weeks.
Remind you for the LCR.
The registry shall issue a reminder for the LCR list on. So it's yes.
I'd like to mention table number 15 year old. This letter I have supposed to file in additional bring into record is Saturday sleep also. So I have prepared the additional affidavit, but the binder to record of health history should not come to swear. So I need some 2 weeks.
You have taken consent of the other side.
Okay. This care after is here.
Okay. With consent of the other side, Mr. L. Mohan, counsel for the petitioner, appellant, prays for adjournment to so as to file affidavit in additional affidavit. First of matter is adjourned today, list after 2 weeks. Yes, item 1. Please come for the first time. Okay, your name? P. Ghosh, counsel for the appellant. Admit, call for the records. P02. Okay. The notice and respond through the by register post with any as well as by through the usual process to be served through the jurisdictional magistrate. The learned court in charge of the process shall ensure that the service report is returned prior to the next date of listing. Notice is made returnable on so data. List on so. IA notice interrogatory application shall be considered on receipt of LCR and service of notice on respond number 2. Corner presses Ms. S.H. Boral.
For order, item number 2-3.
As per your lordship's order, I had filed my objection day before yesterday. I've given them the copy.
Just a moment.
And the copy is not here.
Just we'll take it up on Friday then. All sides are duly represented. Ms. S. Jahanlal APP submits that objection in this interrogatory application has been filed, which is not on record. List on Friday, the said objection may be tagged with the record.
সিরিয়ালি 12 লেগে দিই
Yes, Ms. Khatonia. Your matter.
আইটেম 4
My lord, this matter was admitted on 1/12, my lord.
Yes.
Stay petition has not been considered. my lord.
Yeah. Okay, you are appeared. Okay. This is the condonation application.
Condonation, delay condone, my lord.
Delay condone. Okay.
On 15/11.
Okay. What is this IA for?
I for stay.
Stay. What is the order?
Order of six. Resolving the marriage, my lord, divorce.
Divorce petition was filed by the husband. And divorce has been granted.
Page 8 of the I. সম্পন্ন হৈছিলে 15/11 দিনমান হৈছিলে
Mr. Burman, we find the situation to be unique in this case. You see, you are alleging that the husband has married for the second time. Correct? That is your allegation. And you say that the marriage with this lady at page 27, 29. You have alleged that. Now, what is the purpose of reviving the marriage? Because this is otherwise also, we don't find it, this is a situation where it can be, parties can be reconciled.
there, my lord. Manageable data is there. Hey.
Pardon me?
Manageable data is there, my lord. They are having two issues, my lord. One is data and my son. Data is at the age of marriage, my lord. At this stage, my lord, it will cause difficulty if they get divorced, my lord. It will affect her. My lord. That is my fear.
No, but you see, you have raised that allegation. Now we have to decide it on merit.
Yes.
Because by stay, if we revive the marriage, it doesn't serve any purpose.
LCR already received, my lord.
LCR is received.
One more prayer, my lord. I have another case was filed, divorce petition was filed by the respondent, my lord. That was withdrawn. And immediately after 1 month, with similar ground, but this is the order, my lord. So I think this is not at all maintainable.
Which one?
This earlier prior to this divorce petition, he has filed another petition, my lord. And this was withdrawn by him without any liberty. This is the order of it.
This facts are being considered by the family court.
considered. It would largely.
Oh,
Which paragraph of the judgment?
Page 114. Facts has been narrated.
His Honor, we are inclined to fix this matter on 7th of March. But we can't assure you the hearing on that day because we are in midst of a parted hearing. It's a serious matter. So, but stay, we are not inclined. The facts as narrated in the judgment doesn't lead to any presumption that there's any chance of reconciliation between the parties. Correct?
2013, they are fighting.
Yes, good.
Only thing is that that are grown up.
No, but you see the allegations in the judgment. I did not say that. It's a matrimonial proceeding. I don't want to disclose those things. But you know what are the allegations of the father against the daughter against the father? You have seen that. Reconciliation is just not possible in this case. Heard Ms. P. Burma and counsel for the applicant is an IA, as well as Mr. D. Chaudhary, learned counsel for the opposite party. Next. This by filing this interlocutory application, the applicant, who is the appellant in the connected appeal, has prayed for stay and or suspension of the operation of the impugned judgment and decree dated 17/8/2023, passed by the learned, page 1 and 2. Huh? So. Next, the learned counsel for the applicant has submitted that the divorce petition, which was registered as FC within bracket civil, case number 8 to 9 of 2018, was not maintainable in view of the fact that previous divorce petition was withdrawn by order dated 6/7/2018, passed by the Principal Judge, Family Court number 2, Kamrup Metro, Guwahati, without leave to institute the case again. It is also submitted that the daughter of the parties has attained a marriageable age, and therefore, if the impugned order is not stayed, the future prospects of the daughter for marriage would be affected. Next, para. For contract, the learned counsel for the opposite party has submitted that the parties are having matrimonial dispute since the year 2013, and that the issue relating to institution of the matrimonial suit despite order dated 6/7/2018 has been dealt with by the learned trial court. So it is also submitted that there are narrations in the judgment which reveals the bitter relationship between the applicant as applicant and the opposite party. Next para. Having noticed the nature of disputes which are referred to in the judgment impugned in the connected appeal, it ex officio appears that the chances of a reconciliation between the parties is absolutely remote. Next para. Accordingly, though the court is not inclined, accordingly, court is not inclined to stay the operation of the impugned judgment and decree dated 17/8/2023 referred above. Nonetheless, the court is inclined to expedite the hearing of the connected appeal, for which separate orders have been passed in the connected appeal. Accordingly, this interlocutory application stands closed. In the IA, you write, Ms. P. Burman, counsel for the appellant, and Mr. D. Chaudhary, counsel for the respondent, are present. The LCR is received. First, in view of observation made in order passed today in IA Civil 3423 of 2023, the hearing of this appeal stands expedited. Next para. List the matter for hearing on 7/3/2024.
Record of my lord, FC case number 18/2017 may be called for.
18 is
Yeah, yeah.
this one. This record of FC Civil 18 of 2017, is it referred in the trial court judgment? Except for this order 67, have you proved that record in the trial court? Was it exhibited?
In our written statement, we have mentioned.
No.
but
You see,
it's not exhibited.
if it is not exhibited, then we can't call for that record. Because we can't rely on the, in appeal, we can't rely on a record which is not there before the trial court. So if you want, you can file it by way of an affidavit by them. This order we can take cognizance.
Item 5.
As far as the IA is concerned, Ms. Bonali Bhoya was supposed to file the objection. I've asked her, she is not able to locate. Lordship will give us 2-3 days time, we will do the needful,
Objection not yet filed.
not yet filed. I mean, a copy
Okay,
was not.
we'll fix it on Monday then.
Lordship.
Your name?
And Hassan.
N. Hassan, counsel for the appellant is present. Ms. S. H. Boral, Ms. S. Jahan, learned APB. praised for some. Like this. Ms. S. Jahan and APP praised for 2 days' time to file objection in the matter. Here is considered and allowed. Notice on the next pattern. Notice on respondent number 2 is duly served. None appears on call for the respondent number 2. So accordingly, the court is inclined to appoint list.
Sir, Azad Ahmed is in.
Okay. We can appoint you. It's a POXO matter. Mr. A. Ahmed, counsel, learned legal aid counsel, as amicus curiae to represent the interest of respondent number 2. First off, the registry shall.
Five.
The learned counsel for the appellant shall provide a copy of the memo appeal to Mr. A. Ahmed, learned legal aid counsel for respondent number, amicus curiae for respondent number 2. Within 2 days. List on Monday.
Not
Well, give a date. Monday is
Monday
19th.
will be
Okay,
6th.
19th.
26th is Monday.
Pardon me?
26th, Monday, 26th.
Oh, it will be 26th. Okay. I'm a bit outdated.
I did it, sorry.
Yes, Mr. Chaudhary, your matter. But we got a good news in the newspapers and you are still here.
Newspaper, they are covering, I don't know.
You don't know.
Something, but this one gives us more than what.
No, but we were happy. We celebrated in our house.
The one will tell something will come out.
But I can't turn it back because my wife already ate these sweets I gave her.
I also start after 20 years, might have this issue has again.
Okay.
20 years, I only excited.
But I lost some money on you. You distributed sweets in our house.
That is for other reasons. If this is the reason why you lost, you would have got also.
And we thought good riddance. And we see you again.
But this is the case, my lord, allegation a husband killed the wife, this is the allegation.
Yes.
Now, I just take to lordship paragraph 20, page 24, just my lord, one paragraph, my lord, in the appeal.
Just a moment. Just a moment. We have to wait for a few days for this because the LCR has been sent to translation section.
This is, this,
The LCR is available, but it has been sent to the translation section.
it is not here.
It's not available. Because the office note says they are seeking 3 weeks further time for translation.
The dated by the office, date by the.
That is on 13/2. So. Please suggest a date. When should we fix it? Matter. Suggest a date.
Anyway, my date, maybe after 3 weeks, they wanted money from 13 months. Was it?
You suggest there's a calendar. You take your own call.
3 weeks from 13. Why not, it may be 7 March.
7 March. Okay.
Last down.
Okay.
With Pompa, IMI.
For IA. For Mr. H.R. Chaudhary, Senior Counsel, assisted by Mr. A. Ahmed, Counsel for the applicant. And Ms. Endas Leonard, APP for the state. As well as Mr. N. Ahmed, Leonard, Counsel for respondent number 2. Next paragraph. In your office note dated 13/2/2024 in the connected appeal, wherein it is mentioned that the LCR has been sent to the translation section and 3 weeks time is sought for preparation of paper book. The court is inclined to adjourn the matter today. List this interlocutory application on 7/3/2024. First, before that, you say the LCR may be tagged with the record, even if the translation is not completed within the next date of listing. Then you say list on 7/3/2024.
Come under
In this criminal appeal, you say tag this matter with the connected interlocutory application.
Item 7.
Yes, Michelle.
LCR received lordship, although I have filed an interlocutory application for bail lordship, let a paper book be prepared because I don't have the sufficient material.
In the meantime, Lordship, we have already filed a written objection, but most probably that is not on record.
Okay. But we'll wait the preparation of LCR, as you said, the paper book. Ms. B. Sharma, Learned APP, Legal Aid Council is present. Sorry, as well as Ms. S.H. Bora, Learned APP are present. As per the office note dated 5/2/2024, LCR has been received. Let a paper book be prepared by the registry. List after 4 weeks awaiting preparation of paper book. Post of the connected interlocutory application shall be considered on preparation of paper book.
Okay.
Give a date after 4 weeks, otherwise we'll wait. Give a date after 4 weeks.
Item 3. Item 8.
They made, there is a mistake on my part. I don't have the paper book and no papers actually. I could not file my objection. So Lordship will give me 2-3 days time. By Friday, I'll file it.
You've got
I'll
the
take the copy
And
from
another
him.
thing, my lord, probably there is a letter received by the receiver regarding that, probably the respondent is seeking for legal aid assistance. So,
okay. Thank you for pointing it out.
My lord,
Okay.
the letter is not in the record, my lord.
Is there visible? Whom to appoint?
I don't know whether her name is there. Yes, it's there.
Your name is there. Okay.
S.G. Borua.
Okay. No, just on. Mr. T.H. Hazarika, counsel for the appellant. Mr. S.H. Bora, and sorry, and Ms. Jahan and APP are present. Next paragraph. Seen the request petition filed by the respondent number 2. expressing her inability to engage a counsel to represent her. Stop. Accordingly, the court is inclined to appoint Ms. S.G. Barwal and a legal aid counsel as amicus curiae to represent the respondent number 2. Stop. The learned counsel for the appellant shall provide a copy of the memo of appeal to the learned amicus curiae for respondent number 2.
file করবি না? So, 302 302 informant করছে legally লাগে না possible হয়ে গেছে
Legal aid counsel. But Mr. Hazarika will have to give her 2 weeks to respond because in the letter, this respondent 2 has not disclosed a phone number. So therefore, she will have some disability to contact. So we think that the District Legal Service Authority shall help in making a contact of the respondent number 2 with the legal aid counsel. Correct? So as the letter does not contain a contact phone number of the respondent number 2. The court is inclined to request the Secretary, District Legal Services Authority, Majuli, to contact respondent number 2, namely last page, like last page. So and so, resident of so and so, PS district, so and so. And to connect how with the learned amicus curiae for respondent number 2. Stop. The address and contact number of the learner amicus curiae is contained in, give that notification. That notification. Amicus curiae notification. Is contained in notification number 120. You write a full name, huh? Sumita, Sumita, Gohai Borua. Contact address and phone number are contained in notification number 120, dated 6/12/2023. So as to enable her to obtain appropriate instructions. List on 13th of March. Please give her a copy. This will be an IA. And then the LCR has come.
Yes.
Paper book. Okay, in the IU, right? Record presence of all three, and then say, as per office note dated 19/7/2023, the LCR is received. The registry shall prepare a paper book till paper book. In the meanwhile, next, take this matter when the connected IA criminal 431 of 2023 is listed.
If you have left.
Acha, registry shall reflect the name of Ms. S.G. Barwa as legally counsel for respondent number 2 and listing the matter next. Item 10.
Item 10.
These are lordships. I have filed the affidavit and objection lordships. I don't think it is on record. I filed it last evening. Little
Last evening.
late in the.
We'll take it up on Friday then. We'll take it up on Friday then.
Yes, yes. Deeply obliged.
Okay, both sides are represented. The affidavit in opposition filed by
That is
Mr. S. Chakravarti, counsel for the opposite party is not on record. The registry shall take the same on record, list on Friday.
There is another prayer if they have taken time. LCR was not confirmed, the earlier order. That may be
Lordships, I have
confirmed.
annexed the entire order sheet for the convenience of your lordships.
But still, when it's an appeal, we'll have to call for the records. She's right. But just a moment, this is delay application.
Yes, yes. Lord.
Oh, then we don't need a LCR. Then we would not call for the LCR right now.
Absolutely.
Okay, please renew the prayer when this is disposed of, or this is allowed rather. Yes, item 11.
Item 11.
It's a delay application, minor, before proceeding minor, I may be permitted to file an affidavit for rectification or correction of the proposed title minor.
Cost title. You don't have to file it. We'll permit you to do it. On the prayer made by Ms. S.G. Barwa, and counsel for the applicant, she is permitted to make necessary correction in the cost title, which shall be done in the presence of AOJ Criminal Appeal Section under her signature. Next para, pending amendment of the cost title, issue notice on this application under Section 5 of the Limitation Act, seeking condonation of delay of 269 days beyond the period of limitation in filing the appeal. connected appeal. Ms. Jahan under APP accepts notice on behalf of respondent number 1. So the applicant shall take steps for service of notice on respondent number 2 by registered post with AD as well as by usual process. First stop. The usual process shall be processed by the notice shall be processed by the registry and handed over to the office of the public prosecutor at Guwahati High Court so as to serve notice, so as to enable them to serve notice on the respondent number 2 through the officer in charge of Sivsagar Police Station. First of notice is made returnable on so and so. So the officer in charge of Sivsagar Police Station shall send the service report to the court through the office of the public prosecutor assigned. Next para, list 1. After 6 weeks, give a date.
4.
You make correction in the section.
Item 12.
Here is the legal counsel in this case. Lordship, this matter, the application is for delay of 170 days.
How much delay?
170 days.
Also matters, so.
Also matter, so notice will go. Okay. Same order, just name Mr. M. Das, legal aid counsel. And the police station would be Pulibor Police Station. Pulibor, right? Pulibor Police Station. Amendment is not there. Yeah. Okay. Same date. Yes, item 13.
No, 13, no, 16.
16. Okay.
Supply item 16.
We need some time to file our reply.
Lordship, we have what.
Reply in the not required.
Then it's for you.
Further objection.
On the pair made by Miss.
Hello, sir.
Give the counsel for the applicant. The matter is adjourned today. Mr. S.H. Baral and APP is present. List after 2 weeks. Okay.
Supply item 17.
We're supposed to file objection. Today itself we file objection motion. Let the matter be come after being motion.
When you will file it?
Lordship, today we'll file motion.
Today. If it's on Monday, then
Lordship. Monday, Lordship, I have some difficulties personally. Can it be on, Lordship, 6th? No, no,
Okay.
Lordship, can it be on 27th, Lordship, 27 or 28th?
28 then.
Lordship.
Okay. Mr. M.U. Mahmood, counsel for the applicant is present. Ms. S.H. Baral and APP submits that she is filing an objection in course of the day today. So let a copy thereof be served on the learned counsel for the applicant. List on 28/2/2023.
I know.
Per third item supplementary 18 to 30.
Mr. Prasad will require a chart from you also.
I was. I resume. I'll submit. Into 3 pages.
Huh?
Into 3 pages.
Huh, huh.
Broadly, where.
Just like the presentation made, Mr. Das, the accused paragraphs where the evidence or the judgment, it has been dealt, the relevant documents and where it is lying. That would suffice. Especially with regard to the PWs in one column, which PWs have deposed against particular appellant. Yes,
My next item is fine. If it takes the whole day, we'll take your lordship's leave for today.
yes.
But only thing is that my lord, tomorrow and day after tomorrow. I will-
No, this matter is going to this matter is being taken up day-to-day basis. So I don't think this, within this month, it will be, we will have any dates.
Your lordship, that will fix it in the month of March. My junior will take a date from the court master.
Obviously, we expect to conclude this and then
We will
start
try to
taking up
complete
any
it
other
this-
matter.
Try to complete it by this week.
Huh?
I don't know. We'll try to complete it by this week,
By this week, okay.
at least from my side. So we'll take a date.
You after some, after.
Right, Lord. But yesterday I was,
Mr. Prasad, just see this one, huh? This was. This is how Mr. Das has done it. We find it is good. But you can do your own good practice. This is only for as a sample. You can do a better practice.
but we had a trial court matter, we have to do it, but because otherwise, if you don't have the trial judges, but it becomes very difficult with the. Yeah.
You're right. You're right. Yes.
Hello, yesterday, I was about to complete M. Dilip Singh, criminal appeal number 113 to 117. I was about to complete, Madam. That is a third case which third appeal.
Raji. Without, I will present printer possibly. Yes.
my lord, that is the third appeal that was pressing, my lord, and Dilip Singh. Criminal appeal number 113, 217, my lord.
Criminal appeal 113 and 115 of 2017.
No, yes, my lord,
Dilip Singh is
I was,
113.
I was dealing at 115, my lord. No. My lord. What it transpires, my lord? As I have as I have submitted before your lordship, my lord, that there are as I have submitted, my lord, that there are 8 appeals where oral evidence are there. And we'll try to satisfy your lordship by virtue of this oral evidence. Now, there are 3 appeals, my lord. There are 3 appeals, my lord, where completely on electronic evidence, my lord. 3 appeals. What I will do, my lord, when I was taking your lordship through 115, my lord, that is PW 53, my lord, your lordship made certain queries, and we have to look into it. What my submission is there, my lord, that we'll have to look the original.
Originals
Well,
are here.
We'll do it.
This is the original. This the table.
Acha, oh, yeah, it is
Yeah,
there. No, my lord, that part, what we do, my lord, when I will be taking solely on this 3 appeal, where electronic evidence are.
Okay.
We'll take out all this thing, original, that place it. I think it will be easier for you. But here. Acha, like. My lord.
But we yesterday after the court hours when we rose, the AOJ criminal appeal section came. He showed us order of this court. Of 28/6/2019, by which the original records have been sent back to the trial court. Perhaps after this, during the pendency of this appeal, somebody has been arrested. And so for those, out of those 5 absconders, I think trial has started for one of them.
I remember, my lord.
So this, for all the LCR photocopies were prepared and the original LCR was sent back in presence of both of you. His statement is recorded here.
No. my lord. My lord, while I was pressing Orubhia's case that was submitted, my lord, I have stated that that matter has gone to the Supreme Court, Malad, in a larger bench, Malad, in 2023, the larger bench, even the district matter, there is a paragraph 18, your lordship can do. Paragraph 18. Let me at least clarify this one. Paragraph 18. Nó thấy được cái paragraph 18 thấy 18 lịch trình nặng người voting derivation. We will take it. Paragraph 18.
Yes.
Where you already have seen it, Malad. The larger bench, Malad. It's not a good law. There's Rupiah, Intertas. Paragraph 18. So the earlier case, Malad, Rupiah, your lordship remember, that was a case, Malad, where it says that if they don't resort to activity, Malad, then there is no section will not. But that is how it has been decided. That is not a good law. And that settles the matter, Malad. That settles the matter. That's all. So, in this coming back to Dilip Singh's case, my lord, case number 19, my lord, I was pressing PW 7, my lord, at page 179, part 1, volume 1, my lord. PW 7, 179, where PW 7 has said that accused number 7, you know what remembers the whole. He invited him, he said to him that I have joined UNLF. He invited him to join UNLF first. Now, the second part, he invited him to Nulmati, where the present accused and Dilip Singh was there. The complicity here with 7 and 16 is established. Now, another factor that 16, he go he goes to Kathmandu, the next part. 7 says he's going to Kathmandu. And in Kathmandu, he along with chairman, the Megan, then Nongya, they all gathered. We don't go into details, but they all gathered. That is what I say, and I submit, Bharat, that his complicity and his association with UNLF is established. Your Lordship will continue. See the cross, my lord. The cross part, your Lordship are already gone, my lord. I'll not take your Lordship in details, my lord. That it is all denial.
Yes. Yes.
It's
please
all
continue.
denial. And what is the effect?
Yes.
What is the effect of such type of cross-examination, my lord? My lord, possibly your Lordship has touched it earlier, my lord. Air 1961, Calcutta, 359. This old decision was referred to in 2003, 1 SCC 240. I'm matching both the-
AR 1961 Supreme Court.
Air 1961, Calcutta, my lord, 359. 359.
Yes.
This was referred to, that is, it was this, and I quote as appreciated this, that in 2003, 1 SCC 240.
2003 1 SSC page.
Is 3 2003, 1 is a page 240. 240. My lord, in the earlier case, I'm relying on paragraph 10, my lord. Paragraph 10, and in this case, exactly paragraph 10, both are in paragraph 10.
Yes.
My lord, to 1961, here Calcutta, 359, paragraph 10. The law is clear of the subject. Whoever, wherever the opponent has declined to avail himself the opportunity to put his essentials.
Just a moment.
So those who have some inclination using
Yes, Mr. Das.
My lord. By referring to this, listen, what I submit, my lord, in the first your lordship will, paragraph 10, your lordship, the law is clear of the subject. Wherever the opponent has declined to avail himself of the opportunity to put his essentials and material case in cross-examination, it must follow that he believed that the testimony given could not be disputed at all. It is wrong to think that this is merely a technical rule of evidence. It is a rule of essential justice. It serves to prevent surprise at trial and miscarriage of justice because it gives notice to the other side of the actual case and that is going to be made when the turn of the party on whose behalf the cross-examination is being made comes to give and lead evidence by producing witnesses. It has been stated on high authority of the House of Lords that this much a counsel is bound to do when prosecuting that he must put to each of his opponent's witnesses in turn so much of his own case as concerned that particular witness or in which the witness had any say. If he has asked no question with regard to this, then he must be taken to accept the plaintiff's account in its entirety. Such failure leads to miscarriage of justice, first by springing surprise upon the party when he has finished the evidence of the witnesses, and when he has no further chance to meet the new case made which was never put, and secondly, because such subsequent testimony has no chance of being tested and corroborated. The next, Madam, you just that is 2003 1 SCC 240 paragraph 10.
Yes.
Yes, sir. And this Supreme Court case, Mala, paragraph 10. Incidentally, in earlier 90s, terrorist activities were on peak in the border district of Punjab, and it has practically been an axiomatic truth in the area in question that no one would, in fact, come out of the residential house after dusk unless perforce at 3 o'clock in the morning. There exists no other evidence, nor even there being any suggestion of existence of any other factor for such a perforce outing at 3 a.m. It is a rule of it is a rule of essential justice that whenever the opponent has declined to avail himself of the opportunity to put his case in cross-examination, it must follow that a evidence standard on the issue ought to be accepted. Now, my lord,
Uh, Mr. Prasad, in reference to this case, we'll need your specific submission. You see, this Saran Singh case is on Tala. Now, there are two points in this raised in this case, as pointed out by Mr. Das. You see, this Calcutta judgment was a matrimonial suit, testamentary suit. So in a testamentary suit, it's a proceeding civil in nature, and therefore you set out a case during cross-examination. Correct? So, so far as Calcutta is concerned, it's we are with the said judgment. But this 61 Calcutta has been applied in Saran Singh, which is TARA, disruptive, terrorist activities and disruptive. Here, the same principle is accepted. Now, this leads to a conflict with the normal criminal jurisprudence we know. Number one, that in a criminal proceeding, accused has the right to remain silent. I'll tell you something. This is something I have noticed, and therefore I am telling you. Now you see, there's a case from Guwahati and from CGM court here. What had happened was the food inspector had collected sample of curd, and the accused, lawyer of the accused, asked him a question, and I immediately said that your case is gone. And then I was sitting as an audience there in the courtroom. He asked the question to the drug inspector, the food inspector, did you mix the curd and take sample? He said yes. So you see, incriminating question was a question was asked where the because you see, curd is a item of food wherein the top layer of water will come, and therefore, if no question was asked, it would have been a presumption that the curd's first part was taken. It will contain water, and therefore it's a adulterated item. It could have been demolished. But the question was asked to the inspector, did you churn it? He said yes. Correct. So the deficiency in the prosecution case was established by the defense. Now let us say any case, murder or terrorism or say sexual assault. So what is the nature of question which a accused lawyer or accused can ask? If he asks a question, there will be if the witness is smart enough, he'll give an answer to cover up that. So therefore, right to remain silence goes once we accept this principle. That is number one. But this is a judgment of Supreme Court. We are bound by it. Is second principle which is decided in this case. Here, the principle of preponderance of evidence was accepted in this case of Saran Singh. Now, if we accept this, it goes against the well-established principle of criminal law that in criminal jurisprudence, it would only be strict proof and not preponderance of evidence. So there are the two reasons for why this aspect has to be dealt with.
Welcome.
So you'll have to address us on this.
Now, what I would submit, Madam, as a logical evidence that in the trial court, there is an appellate court. The argument that is developed on the basis of evidence that has come on record, on the basis of cross examination that has come.
Just a moment. I'm sorry to stop you here. Just tell me, is there any provision in this act, which is what do you call the UAP Act, where the reverse burden lies on the accused? any provision in the UAPA of reverse burden?
I don't. You already, can't you repeat it again, madam?
No, reverse burden, because the defense will have to prove that he has not done it.
He has not done.
A presumption against, presumption in favor of the prosecution, is it there?
There is a presumption section is there, but not in the line that your lordship has said. No, the only few sections are there, madam. UAPA. Gotcha.
Reverse burden that he has not done it. 43 E.
There is a presumption. There is presumption.
No, this presumption is only available for 15 if conditions A and B are there.
Otherwise, there is.
Otherwise, there is no presumption. Because Mr. Das, if although we are bound by the Supreme Court judgment, but if this presumption in respect of other offenses are not available, then perhaps the principle of preponderance of evidence
Exactly.
is something we'll have to deliberate.
But that is what I would say, that a oral evidence count. Mother, 307, mother. Now, his evidence, why can't that be accepted? Section 60. Mother, that must, and if that had to be discredited, that has to be discredited by cross-examination. Simple, as simple as that, matter. Now, beside that matter, can I, if I am on the appellate side, can I develop a new argument before the appellate court? If that point was not available in cross-examination and the trial court has not ignored that particular cross-examination and
No, because you see that's why we are asking this to be deliberated. You see, what is happening is in the example which I gave, third. Now, if that is not proved, if the churning is not proved, then what happens is that it is the prosecution which fails.
Man.
Because of the fact that it's a normal tendency that if you see, you prepare any food in your home, like for example, let us say very simple item as dal. We prepare pulse in our house for the purpose of taking it with rice, correct? Now, from the oven, if you take what you call this lentil in your plate, you'll only get water. So therefore, we know that if we have to take lentil, then what we have to do is that we have to churn it and then take it. It's a simple example. So therefore, if there is no proof coming from the prosecution that the dal or lentil or this pulse was taken without churning, then perhaps the food quality would be bad. So why in a criminal prosecution, it's the burden comes on the accused to ask questions. He has a right to remain silent. You see, let us take any case. A has been slapped in the market area.
But that is not the case here. If your lordship will again go to read.
No, I'm just asking, you see, I'm just clarifying. You see, a man has been slapped in a market area. And then he's been prosecuted for slapping A. Now, the defense will have to take a plea of alibi if he wants to say that he's not there. So plea of alibi has to be, you see, criminal jurisprudence says that if you take a plea, then it has to be, the burden will fall on you.
witness,
So if
my
a plea of alibi is taken, it is the burden of accused to prove that no, he was not there in the market area. He was there on that day. He was at X place. Correct. Now, if he doesn't take that plea, and the prosecution fails to prove that A was present in the market area, who was slapped. That the question of the accused coming and asking the question that you are not there will be counterproductive. He'll come and say that no, I was there.
those illustration will not apply in this case. At
Hmm.
least those illustration which your lordship has thought about it. It's not a case in, with, while examining PW7. PW7 is very straight. It's straight. It's straight. That is what I have said. Straight. That your lordship has to find out where he has, how to misread his evidence.
Okay.
It is not-
Okay.
Your lordship will not get a better witness evidence than this fellow. PW7. If your lordship wants, I can read it again, but
No, it's not required.
let us not confuse with any other. I am citing those days on the basis that there is a simple citation and denial. That's
Yes.
my lord. I'm just submitting on paper, submitting this PW7 shortly, my lord, because two accused are involved in this case. Accused number 7 and accused number 16. On the evidence of this PW1, PW7, these two accused, at least their membership is section 20. So you always will try to just see there is a positive evidence. There is a positive evidence that PW7 has deposed that while meeting accused number 7, accused number 7 stated before him that he has joined UNLF. Number 1. Next, Next, accused number 7 invited accused PW7 to join UNLF, a positive evidence. Next, Your Honor. Accused number 7 invited PW7 to Nunmati, where he met the present accused, that is PW60, accused number 16. Positive evidence. Next, all they gathered, they went to, he was invited to Kathmandu. Where in Kathmandu, accused number 16 arranged meeting with R.K. Megan, accused number 19, the chairman of PW7. These are the positive evidence which has not been dispelled and disturbed in cross-examination. That is my submission. That is my submission. So by this evidence, PW7, my lord, both accused number 7 and 16, their membership is proved, my lord. Is judgment to DSM, Harry Atlas, judgment to part 2, 5. Present, para 39, 66, that of my. Number 6. Then 24. That was at 52. Okay. 62. Your Lordship, I do not remember whether Your Lordship has noted the judgment paragraph matter yesterday in this case. Then the question that was put, whether Your Lordship has noted that.
We recorded only what you submitted, but we don't know,
This part I have.
because you
noted,
see,
submitted part, I
you,
submitted part of-
you,
in, judgment part, Panav.
just a moment,
62, paragraph 62 and 63.
just a moment.
64.
For N. Dilip Singh,
Yeah, no, and Dilip Singh, yeah.
For N. Dilip Singh, I don't think you have cited the paragraphs.
Judgment paragraph, no?
Paragraphs you have not cited.
Then for Your Lordship, kindly 62 and 63 of page 979, part 1, volume 5.
9,
The judgment paragraph is 979.
that's good. Para 62 and 63.
62 and 63.
Yes.
62. Another important witness in the case was PW7, who was an engineering graduate and was doing business in handloom and textile. He was also the owner of Messrs. Donghae Enterprise. In the year 2010, in connection with his business, he used to visit Bangkok sometimes. He also stated that he was also involved in business of sending students for MBBS course and language course in China. And in that connection, he visited China 8 to 10 times between 2005 to 2009. He sent about 10 students of for MBBS course in China by charging rupees 2 lakhs or less for each student. But in the year 2008, the Chinese universities hiked the fees, and as a result, it was difficult for him to send students. Ultimately, in the year 2008, he visited China and uh, he visited China, but in the Chinese fees. Ultimately, in the year 2008, he visited China and contacted Ms. Cheng, the general manager of Chengdu Source Management Consultants Company Limited. He also stated in the last part of the year 2008, he met his old friend Oinam Somerjit Singh, accused number 7, at a hotel at Guwahati, who also had his mobile number. He said that since 1990, he lost contact with him, though he was a childhood friend. They sat together in the hotel and discussed about themselves. During the meeting, Oniam Somerjit Singh, accused number 7, told him to become a member of UNLM. The witness category. During the same meeting, accused number 7 told him to become a member of UNLM. The witness category rejected his offer. After about a month, accused number 7 called him over his mobile phone and asked him to visit a place at Don Martin, Guwahati. And when he went to the place, Oniam Somerjit Singh, accused number 7, introduced him to Philip Singh, accused number 16. They discussed primarily about sending of students to China. Philip Singh, accused number 16, was not known to the witness from earlier. P7 also stated that in the month of December 2008, he went to Kathmandu, with his wife in connection with his handloom business, and prior to his departure to Kathmandu, point number 7, accused number 7 called him and informed that accused number 16 and some of his friends were in Kathmandu. He told that they were interested in, for sending students to China and also requested him to contact his source in China for sending a student. The witness also stated that the contacted Miss Wang and narrated about his intention of sending a student. He was told that one Mr. Seng was in Kathmandu and asked them to meet him. They were received by Mr. Cheng in Kathmandu airport, who took them to a Chinese hotel at so and so. From mobile phone number of Chang, the witness contacted accused number 16 and informed him about his location, and 16 came to hotel where they were staying. Accused number 16 introduced him to his friend Mr. Joy Singh, that is accused number 18, and Thamal, accused number 20, and in turn he introduced them to Mr. Sen. They discussed the possibilities.
Taking back.
So, paragraph 62, the learned trial judge, he appreciated PW, the deposition of PW7. And he accepted what he has deposed. So nothing could be said that at least this paragraph, the trial judge went wrong. Dua salam. The orders are hearing now. Translate. So my submission is that paragraph 62, while reading paragraph PW7 Marot, the trial judge has accepted what he has stated. He has
this, this I was PW 89,
PW 89,
IO
84.
84.
84 is the last return, madam. That is that. One minute. That is paper part 1, volume 2, your logic. Basic math. Some missing as a day, but I don't know.
Was we are searching as to who has proved one exhibit 153.
Catching as a day.
No, this IO has not proved 153. We are searching for exhibit 153. Who has proved it? Dr. said PW 53 also proved something. Did he prove? Yes,
Madam, okay.
153. Yes,
153, my lord, page 411.
411.
Seventh paragraph. This PW 76 for the examination.
411. 153. No, we will. Yes. Please come to. Page 995.
Paper.
Of volume 5, paper, part 1.
Yes, madam.
This examination report.
153 is a forensic report. And PW 76 is a forensic expert.
76.
76, PW
PW 76 is at which page?
393.
Volume?
Part 1, volume
2. 76.
76. Rajendra Nath.
Rajendra,
Page number
393.
393.
At page 411, he has referred to 153. Exhibit
411.
400, seventh paragraph. From below, it's third paragraph. Exhibit 153 is at part 2, volume 3.
Part 2, volume 3.
Part 2, volume 3.
Ah, yes. Part
Page
2, volume 3.
723.
723.
23.
Yes.
Photo of examination of a hard disk in a laptop. Lenovo laptop.
Mr. Das. I'll show you, come to page 995, volume 5. Part 1.
part 1. Yes, madam.
Correct. Entry number, serial number 374. 153 is examination report. Correct?
995K. It's 995.
995.
Yeah, 1950.
Yes, madam.
It's in there. 153 is the examination report. 153 1 to 153 14 are signatures.
Madam, exhibit
Serial number 374. Exhibit 153.
334, yes, 153, yes.
correct?
Yes.
And 153, 1 to 153, 14 are signatures. Now, page 721 of volume 3, part 2 is the document.
Long 342. Yes, madam.
Correct? Now, this is
Yes.
up to page 727 is that report. 27 is that report. Correct? Now, 727 is exhibit 153-1. 727. Signature is 153-1.
Yes.
Correct. Now come to next page, 728.
738. Yes,
This is signature 153-3. But the text is in, I think it is Manipuri.
please, no,
No. Text at page 728 is Manipuri.
720, the language model, yes. Yes, yes.
Correct.
Right.
But that
Yes.
is not proved. The contents is not proved, signature is proved only.
But as we have said, madam, not all the contents, only the content which is
No.
relevant.
You are missing out. You see, come to page 723 again.
Madam,
Now this exhibit is number one is Lenovo laptop. Number two is 10 numbers of SIM card. 3, 5 numbers of handset. 4 is 2 number of pen drive. Therefore, contents of letters are not proved.
reporter, yes. Yes,
Only that much.
madam, this is the report of examination. And this ends at page 7 to 6. 7 to 7, madam. This report of examination ends at 7 to 7. This is a different context, madam. Reporting, sir. There's something.
So we don't know. We're just putting it to you.
No, that is, sir. It's complete different, on different subject, madam. Not related to this 153, 153. I don't know. Examination report. In page 27, you are also fact this end of exhibit 16, end of analysis report.
We are not interpreting anything. We're just putting it to you. The contents of the reports of examination. You see, we are only putting it to you that the examination report is there. But what is the report is not, the contents is not proved. What has been proved, we don't understand from it. A document is marked as an exhibit. But what is the intention of proving, we don't know. You see, in a postmortem report, what do they prove? They prove the postmortem report, the signatures thereon, and then say that the cause of death is so and so. We're just putting it to you. We're not formulating anything. We're just putting it to you.
No. This one, regarding examination which your lordship is striking at 153. 153.
No, just like yesterday, we are just taking up one sample and we are trying to analyze what has been examined, only that much. Nothing else.
What he has examined, he has given a report of this, and that ends at page 127. Then page 728, that is on the different context. It doesn't lead to this.
So whatever we are not, we are not questioning you on that. We are just bringing it to your notice that this is what has happened.
I'll come to this at a later stage, Bharat, when I got the email part. Madam. So I was only the paragraph, and I say that 62 Madam. The learner treasure has rightly appreciated PW7. That is it. Now, if you also has noted the
Para 62, 63, you said.
questions, you've also noted the questions, Madam. The 330.
313,
330.
just now,
330 questions, Madam.
just now,
That is at part one, volume four, Madam.
just now.
Part one, volume four. That page start with 841, Madam.
No, not recorded.
840.
313 statement.
Yeah, 200.
At page,
At page 840, it starts, Madam.
840, volume 1.
Yeah.
Part 1.
Yeah,
Volume 4.
that volume one, part one. Volume
Volume
two.
4.
But question number 4. 841. P27 individual so and so has deposed that he and his wife were basic by so and so that Kathmandu, and from there they went to hotel where you 16 met him at hotel and encouraged him to okay again Nokia 18 and Thawan so and so and discuss everything. He just said false. Anyway, father. Then question number 9. PW16, Kubara deposed on so and so, he was posted at City Police Reserve Party and was attached to SP so and so. And on that day, he did the informant that one Nobin AP was staying with his family at Upper Bari, who was active member of UNLF. Accordingly, around 7 p.m., along with SP City and intelligence officer of Army, along with source, went to the place and pick up accused number 2, who admitted to be the so and so human resource being so and so Tomba. Accused number 1, chairman UNLF, vice chairman UNLF. Cheese, SR, laptop 3, so and so 1%.
Now, Mr. Das, we were a bit distracted when we are reading your this question 4. I'll tell you why. This evidence of PW7 is in volume 1. PW7. Page 179. Correct. Now, come to page 183.
83.
183. And 183, just 182 last page, last line. We went together at hotel where they were staying and met at the lobby. Mr. Nongyai introduced me to his friend, Mr. Lancha, Mr. Thabal, Mr. Sakhen. I could understand that something conspired with them and they were not happy to see me. I was asked to have tea in the lobby of the hotel where they were staying. All of them went together at one adjoining room of the lobby. After having my tea and waited for more than 30 minutes, I went towards the room where they were talking. I could hear loud noise from outside. I opened the door a little bit, but did not enter. All of them were in a confusion, shouting at one another. They were talking in English. They were talking about the purchase of weapons, AK-47, RPG, M21, and about the military training of UNLF cadres in China. Correct. Now, you see, question number 5 at page 2841. Certain names are dropped here.
I humbly sorry for that. This question number 5 was put to me, but that is not related to him. Because 16 it was not there. 16 is not there.
No.
Only
And there is
7 you
one,
have on it.
and no, and there is
Because
one more
total-
part. You see, without being audible to you, we were discussing together something. Correct. Now, this question was put to he is PW7. PW7 was not in China. No, sorry, this A16 was not in China. But he's aware what is going on in China, but he was not there in China.
Oh, yeah.
Correct. So if in our absence, you asked Mr. Prasad what we were discussing. How does it implicate A16? You are saying that it implicates him so far as membership is concerned.
Understand your lordship query, but Anna, what I am saying, when you go by the easy way, that is But I was saying that the first place that you met, case number 7 at Normandy. Section, then at Kathmandu. That is sufficient. That is sufficient. Why do you go for China? That comes in 120B or 20B or 18 matter. Because all of them, they discuss, etc., and knowledge what to do. They had a knowledge about it.
So you see, we are,
for
dis-
18,
we,
for
no, you see, we are disturbed with the fact.
For
That's
18.
why we are asking you. Now, this, I give very horrible examples. I give one more. You see, along with you four, there is another man sitting here by your side. He's assisting you. Let us assume that. And we have been deliberating for last 8 days in this matter. And today we come to know that suddenly the police comes, arrests this fifth man, which is sitting alongside with you. And police comes and arrests here, saying that he's a man of a band organization. Now, you see, we all in this room were not aware that he was a member of a band organization. And we were all deliberating with him. We all were sitting and then having 8 days of full court, what you call, full days proceeding with that person. Now, would it make an association with this fifth man, non-existing man here, and connect everybody of us being a member of the band organization? Because you see, we were there 8 days together.
Yes. When by associating with you, start doing those activities for the bad numbers. Yes. Not simply, with a simple seat as your logical setting. Possibly, you don't know, as your logical setting, you don't know here. But once you know, you start sharing your thought as well as the activity, etc., and also for propagating or for promoting their activity. Then of course, you're right. Then, my lord, after PW,
Question number 4, 9.
then your lordship, I have read question number 9, then your lordship will come to 13, my lord. 13. At page 843. Um, my lord, question number 13. In division PW7 has deposed that A7 Somachari had introduced him to you, living at Nonmati area. You discuss about business of sending to China. In December 2008, he went to Kathmandu with his wife in connection with handle business, and Somajit A7 informed him that you 16 and your friends are at Kathmandu and would like to discuss sending students to China. What you have said, it is false. Then 14. PW7 so and so has deposed that he and his wife were received at by Chonko so and so, and from there went to a hotel where U16 met him and introduced him to Nongai, accused number 18, and Thawal, accused number 20, and discussed sending so and so, so and so. It is false. Then question number 15, PW7 Nongai has deposed that he visited China so and so, and met Your Lordship. No, now Your Lordship will come to question number 16 only. No, 16.
I'll make only one statement which might induce you, Mr. Das. I'll just give one statement which might induce you to send students to foreign countries. You check in your internet, mobile, you just check it out. Students going to China, and you will get an information that about 23 to 25,000 students, Indian students, go to China. And 80%, more than 80% of them go for medical education because it is cheap.
Cheap, right?
Right.
Yeah.
Now, cost of medical education in India would be around 8 to 10 lakh per year.
Well, quite true.
And if you send students to Europe, it would cost about 25 to 40 lakh rupees.
Yeah.
What people say for medical education,
But that is why Ukraine.
Ukraine and China is cheap.
Yeah.
China is cheap. So even if we say cheap at China would be, say, let us say 10 lakh a year.
Yeah.
10 lakh rupees a year for one student. 20,000 students is how much? Now I can't multiply.
What if it,
How much?
it comes to 2 crore, I think.
No. It will be 2,000 crores.
2,000. Yeah.
2,000 crores.
Hmm.
So now you will also think, why spend time in this matter?
But
2,000 crores.
but
How much does it come?
I don't know,
20,000?
maybe all my juniors, they'll be motivated by that. They have got time. I'll not.
No, I don't know. In serious way, you're motivated. I was, in fact. 10 lakh rupees into 20,000. 10 lakh,
Hello.
200 2,000 crores. Huh.
Hefty amount, hefty amount, hefty amount. And there is a commission there.
And you see, this question you were reading, it merely says that they had discussed about sending people to China. So therefore, incidentally, when the meeting of mind was there, at that time, it was not terrorist activity.
This because of border. Sending of students studying in foreign countries, that was easy. That was easy. But now it has become little difficult.
No, I don't know. I'm just, you see, I just told you with this example,
Because
and what I do in my spare time is read all those things which are absolutely unnecessary and then jump to a conclusion. That's why I said I can say something which will motivate you. Check in the mobile, you'll find it out. Students to China. Just check it. Just check out. Indian students in China. It's 20,000. 23 to 25. Internet says.
But at a last, I will start with the next case of G10.
20 to 25. Okay.
Indian students.
Yeah. That is
80 to 90% studying MBBS.
80 to 90% MBBS.
so why not Cheng will do it, but
Okay. So this is over.
but this is over. I'll come to
Oh, okay.
Chicken.
4, 9, 13, and one more you are saying 14.
that is yes.
14 and 15.
I say
Okay.
14 and 15. 14. In, I'll be addressing on, appeal number 10, that is criminal appeal number 115, 115, 2017. Is detention. Here also you also will find
Yes.
sufficient oral evidence, my lord, which will prove section 20 as well as his name appears in the officers list. And 121A and 18 mark. Now, as your lordship has earlier in the first half, your lordship has said, if anybody sits among the, let's say, in this case, your lordship will find he has overt action. Some overt action. That is oral evidence. Now, first I will take your lordship to PW 17 at page 211. That is part 1, volume 1. There is only one paragraph, my lord. One paragraph in respect of detention. That is MC at page 111.
211. 211.
Yeah, 211. 211. Paragraph, second paragraph. I have 3 brothers, that is MCO. I have 3 brothers and I'm eldest. The second one named Jayanta Kumar joined UNLF in 1982. And till today, we do not have any touch with him. We have 3 sisters. Youngest one is Londoni Devi, who eloped with Jiten, who is a member of UNLF. As she had eloped, we have boycotted her. It is only this much of evidence deposing positively that one of his brother has joined UNLF and Jiten Singh is UNLF. And he has eloped with his sister, youngest sister, that is Londoni, that will come later. There is evidence we can. Now, on this, you also will find absolutely no cross in the cross examination. Nothing, only with regard to Rakesh. All the cross-section that was done, only with regard to that is in the next page, 211, 212. That is money. That is all what we get from this witness manual, PW 17. Next, your lordship will come to PW 26 at page 231 of the same volume.
Table 26.
231. Has your lord- oh. PW 26. I am BA and after my education, I am doing the business of grocery as well as hardware shop at Impal. During 2008 to 2009, I was doing the business of transport contract of FCI. I did not have any vehicle of my own, but I was taking the same on hire. During that time, doing business was not very smooth. There was a lot of demand of money by the underground groups like UNLF and many others. We used to pay these demanded money monthly as well as yearly. The underground people used to come and collect the money from our establishment. I cannot recollect the amount of money today as it is long time now. At present, we are not paying any money to any extremists or any underground organization. The last we paid in the year 2009 when we were doing transport business. In the transport business, I was appointed as nominee for the transport of rice, and for the purpose, we were paid 4% to 5% per trip of truck. In each trip, we carried about 300 to 400 food grains in the truck. In the collection of demanded money, one person by the name Indramani used to come to our establishment. We do not pay to Indramani, but he and one G10, case number 10, belonging to UNLF, collected the money from nominee. I had an account in the Impal Urban Cooperative Bank. In the said account, G10 forced me to deposit all the amounts of the nominee amounting to rupees 3 lakhs, 10 lakhs, and so on. In total, the deposit of the above has come to 40-50 lakhs. Thereafter, there was a demand of taking out the money from the bank, and I handed over to one Mr. Ranjit. There was telephone call from UNLF who directed me to hand over the money to Ranjit, and accordingly I handed over the amount. Sometime in the year 2009, I was arrested by Impal police and was kept under detention for about 3 months on charge that I was supporting the underground group. Thereafter, I was released. During that period, I had some where about 40-50 lakhs of underground money belonging to UNLF. After my release, I handed over all the money to Mr. Ranjit belonging to UNLF. This amount was given by check. One Mr. Suresh of UNLF directed me to pay the money, for which I paid the same to Ranjit. Thereafter, there was no dealing with UNLF. Another underground group. I can identify Ranjit and Jiten, but I have not seen them in the court today. Exhibit 58, that your lordship, my friend has already said they were present. Exhibit 58 is a seizure memo, so and so, so and so. Then by which I have handed over 8 numbers of document to NIA. Exhibit 51 of my signature. In the state list, I have given list of 14 nominees. Order so and so. Impal, in the name of MS Gautam Bharat's son, so and so. Then your lordship will come. Now, in the cross part, it is true that there are many underground groups in Manipur numbering about 20-30 of underground under-defined name. There was no demand letter from UNLF to myself or to our establishment of any kind. The demands were made over telephone. Jiten was introduced as a member of UNLF by Indramani. I do not know whereabouts of either of the Said Indramani and or Jiten. I also did not verify whether the said two persons were actually members of UNLF or not. There was no threat by the show of force by using bombs, gun, and other weapons to me or to my family. Due to lapse of time, I cannot now remember the details like dates, check, numbers, and amount, etc. of the particular transaction which I have mentioned in my examination sheet from my account of IUCB Impal. I do not know Ranjit personally. However, the person who came to me identified himself as Ranjit Singh. I only saw him once. I would be able to identify the said Ranjit Singh now. It is true that there were many instances of extorting money from businessmen or government servant of by impostors by posing themselves as members of underground outfit during those periods while I was doing business in Israel. The demands were made by underground outfit. I was taken to the court of judicial magistrate by the official NIA for giving statement under section 164. I also came out of the court together with the official of NIA NIA under section 64. The said statement was recorded after my release from jail. I deny the suggestion that I got the said statement as written by NIA. I also deny the suggestion that I did not give my said statement. I do not know Suresh personally. I have also not met him at any time. I mentioned about his name as person who telephoned me, told me that his name was Suresh. I denied the session that I did not give any amount of money to UNLF at any time, and there was no transaction between myself and my firm with UNLF at any time. I also denied the session that I am giving false evidence as tutored by NI. I further denied the session that I am giving false statement. Then, in the reaction, I clarified that I have received three from one G10 of a telephone. Now, on this evidence, my summation is that, my lord, he positively said that G10 belonging to Illuminati collected money from the nominee. And then this amount was deposited in his account, and after accumulation of 40-50 lakhs, that was taken by them. Now, your lords will just see the exhibit, my lord, that your lords will budget. আচ্ছা কেনেকুৱা কি কালি কিমান আছে কালি ঘৰ চাবলৈ তেনেকে নি আহি পেলাই কৈ দিব আৰু চাব বুলি কিবা এটা কৰক আৰু। exhibit কেটা দিয়া है exhibit 58 page 262 part 2 volume 2 part 2 volume 2 part 2 268 My lord, your lordship will find exhibit 58 at page 268 of paper part 2, volume 2.
Volume?
Part two, volume two.
Part 2, volume 2. Page
My lord, page 268. That is a
268.
actually production memo. That is a memo. My lord, there's a production memo, but my lord, the relevant you will find that is the account statement model which is executed in part 2, volume 3. Part 2, volume 3 at page 555.
Page
555.
555.
That is the account statement. Put it, 555, put it. Put it.
Yes.
He has exhibited this account statement model. Yes. And there you also will find 559. Has your lordship got it, my lord?
Yes.
My lord, I will just say, although this is a bank statement, not proof according to bank rules, but only to support his statement. He stated that I received, collected this collection amount was deposited in my account. It went up to 40-50 lakhs, and thereafter they demanded, and if that part is accepted, my lord, need not go to this statement at all. This statement is produced only to support that, yes, they have attention. You also will find at 559, there's a big amount of money that was debited. You also will find 46 lakhs, 10 lakhs, so on, my lord. The whole your statement, my lord, you will sign. And then at page
Mr. Das, you're proposing us a very difficult task. You see, come to this PW 20, this is PW 26.
26, my lord.
PW 26 has
36.
proved exhibit 58.
One.
Correct.
PW 30, just one.
And
36.
exhibit 59 is his statement under section 164. These are the two things he has proved, 58 and 59.
My lord, just one.
Page 132.
PW 36. No, 132.
26. You are referring to page 26, PW 26.
You know,
And then you are saying that this is accounts is proved. That's why we are asking you that.
26 will equal to 26.
Page 232,
Madam,
PW 26, it does not prove anything except 58 and 59. So he is not proving that statement.
No.
Somebody else is coming with that statement and saying that,
By this statement, what we get? Correct. We get,
no, we'll come to that statement. But you see, who has introduced this in evidence? You see, a best person is in the dock. You don't ask him to prove that. A third party comes and proves the document. Whose document? PW 26's document. Can that be done?
no, living aside that, because in the evidence, thing has come, that's why I'm producing. Living aside that, we go solely to the verbal statement, oral statement of this witness one.
No, he doesn't say that. You see, if he gives a statement which is based on a documentary evidence and does not prove the documentary evidence, oral evidence is lost.
No, why?
Burden of proof is under 101. You look at 101.
No, nothing. So minus the oral evidence matter, minus the document evidence. Now come to his oral evidence matter. That's simple. Your lordship will kindly leave aside the other part matter. Come to this. Now he says that I used to pay extorted money.
You see, there are, if we examine this evidence, there are many loopholes in this. Number one,
Quite true.
you may not, no.
Just 1 minute, let me sort it. It will become very short one. This evidence along with other evidence one. You'll have to.
No, I'll come to this evidence first, then we'll analyze it.
No, otherwise, no, it will become, because it will.
No, you
From what-
link it up. Mr. Das, we are not asking you not to argue.
No.
But what we are saying is that if we read an evidence independently first, then we link it up with other witnesses. There may be hundreds of witnesses, but we'll have to examine the correctness and the reliability of the
Exactly, correct.
evidence.
Only to that.
Only to that
Only
extent.
to
Now
that.
you see, his first line is that I am the nominee. Correct. Now, if you have understood nominee word correctly, then in a FCI contract of transportation of rice, while in other bench I have dealt with it. Correct. When I'm taking a bench 4, I have dealt with these issues. In case of a company or a body corporate or a society, when a tender is submitted, along with the tender, the members of which this firm, company or society is constituted, they nominate one person to be the person who will sign and do every document, and they rely on their in this person's agreement to bind the company or firm or society. Correct. Now, incidentally, when we were arguing, I had opened up one such tender. It's open. In page 15 of the tender, we checked at random. So this, what has come out is Odisha, distribution of rice. And there in page 15, this is explained what we were thinking, that nominee is only that person. But you see, come to page 268, you are referring that. Production memo.
26.
Yes. Now here is, you see, item number 1 is list of 14 nominees nominated by MLAs for various constituencies. So this is not that he is not a contractor. He is a nominee of the MLA.
Oh, no,
Yes. Now you'll have to show us that he is reliable when he says that he is transporting, he is in the business of transportation, because he is a nominee of the MLA. Correct. He doesn't say that he is a tenderer. Now in that tender, there's a condition precedent that he must own a vehicle. If he is a tenderer, he says that no, he did not have a vehicle, he took it on hire. So you see, number one is reliability. When you come on reliability, then the first, we are in the periphery of the reliability now. That is number one. Number two, he says that he paid amount by check. Now, he does not know the name, the date of the check. And even if we accept it, then again from the bank, Nia could have got the particular entries. Now you got a statement of account. You proved it by some other witness, that is exhibit 125. Please assume that I am the accused and my brother is the witness. Now he has produced certain documents and he does not prove it. It is proved by my court master. Now, a statement of account is a document qua the bank and the this witness PW 26. How can a third party come and prove it?
We'll come to that. Now, what is the issue in this? Because we are going little away from the issue. What is the issue in this? Madam, we are not, we are only trying to see this witness, that this witness, he comes and said that, say straight away, I have paid money to Stan. He comes and collected, he is a member of the company. Now, question is whether he has to prove that thing by document.
We don't know. We don't know. You see, if it goes by what you call votes, you see, no. What I'm saying is that if it goes on votes or number of people who have said it. Now let us assume, you see, we are conscious of what is now coming up in TV shows, in the newspapers. All the members of opposition are accusing one particular person of murdering democracy. Not one statement. Every day you find statement made by X, Y, Z, A, B, C, D, 26 people. Every day a statement is coming out that one particular politician is murdering democracy. Now, if we go by vote count, 26 people say daily. Does this one particular politician become accused?
Definitely not.
Definitely not. Why? Because of the fact that you see this, when it comes to murder of democracy, there are certain parameters and those has to be proved to show that the democracy is lost. And that is why we say that it is not, it is not so.
Both ways, madam. If the democracy is to be survived, madam, then one has to do it in a balanced way. It is not that it has to be tilted this way to the perspective.
No, we are not on that. What you are saying is that, you see, somebody is accusing, there has happened a murder of democracy and there is one person who was being named. Now, we don't go by that because we go by the proof of which is shown.
Exactly.
So,
But-
except for the statement, there is nothing.
Madam,
Here also, except for the statement that there was a transaction, you see, we were just discussing
madam,
before we came here that we too are normal people.
Madam.
Before we are speaking of a time before our elevation. One day in a pan shop, we were both quarreling. My brother wanted to buy a MiG-21. I wanted to buy a tank, what is called Patton tank. And we wanted to do something. So we were both arguing
madam,
in a pan shop in the very public audience. Now, looking at us both, our financial condition, our status in the society, supposing we had an argument, would it make us terrorists? We are shouting at the top of our voice. He says, no, we had to purchase MiG-21. I said, no, we have to purchase Patton tank. And we are arguing.
madam.
A very, very strong argument we were making in a pan shop. Everybody was listening. And then we came out.
Everybody was hearing.
Yes. PW7 says so. He heard people shouting, top the voice, wanting to purchase AK-47, RPG.
Yes.
Well,
Yeah.
even you see, if you cross a beggar, you don't pay him, he will say, "Ah, goli mari dibo lage."
Matlab, that becomes a issue. Then your lordship will say that your lordship will, but when it becomes in reality that PW3 and 4 have said that I have
No.
seen all those arms and ammunition there. Then in this case of G10, he was caught with arms and ammunition after was lost. So question come combined together all this evidence, whether it is
Which page is the charge sheet of Jiten? Charge sheet of Jiten?
Your lot will find. No.
Part 1 volume?
14 to 11.
1.
14 to 11. Huh? And 14 to 11.
Volume 1 page?
Page 67.
57 is the
57.
67 is the
67.
page number 1. Huh? It is 14 to 11.
Serial number 10.
Serial number?
10.
10. Jiten Singh.
You also will find at page at page 67.
67.
G10.
60 is not charged with arms.
Pardon?
He is not charged with offense under Arms Act.
He is caught in different cases.
No, that's okay. But you said, since
No,
you said,
I said, otherwise he could have been charged under section 15 and he could have been pursued under section 16. That is not the case here. But incidentally, to prove that he is a member minor,
if he's not
In
charged
other
with it, if he's not charged with Arms Act,
yeah,
there is a presumption that the arms seized
no,
would not be.
not in this case, not in this case, other case. Other case. In other case.
That has to be brought in evidence in this case. My brother is absolutely right. You see, in a criminal case, if you want to rely on certain facts which belongs to other proceedings, then that proceedings has to be tendered in evidence in this case and being linked. Because you see, let us say a very small example, a bouncing of check. A man habitually gives check and it is bounced. So his check is bounces 5 cases and I come to know of it. What I'll do is that I'll call for the proceedings of all these 4 cases and then tender in evidence that he is a habitual offender with regard to the bouncing of check. And then proceedings take up. Now, if you see, if I'm driving a car and I have violated the laws for 3 occasions, then I am to lose my driving license. So therefore, the police will have to check me for an offense and punch my license for the first offense. So 3 offenses and then it goes. Now, supposing the what you call this, I'm not put to notice by punching off my driving license. Then for the 3rd offense, you can't cancel my license.
Yes, because he may not be allowed to continue with a license also.
So therefore, I may, as an accused, I may be put to notice that yes, 2 offenses have already taken place. We have punched your license twice. And therefore, 3rd license is the 3rd chance. So therefore, you see, it is only when these 2 cases come, they are tagged and the license is punched. Then only 2 offenses are made out and 3rd I lose my license. This is what I understand. I don't know what goes on in practical, but theoretically under the Motor Vehicles Act and Assam Motor Vehicle Rules, this is what is prescribed. Now, therefore, you have to show before us that you see, we are proceeding with non-premises. that bad character in a criminal proceeding is of no consequence. So therefore, if a bad character goes, and a man may be a habitual offender, but if you don't connect it, even in Maharashtra Control of Organized Gangs Act.
We have tried to connect it.
Okay.
We'll just,
Okay, okay.
no, just resting on this evidence, Madam, 26. What we get, Madam, that my submission is that, Madam, that shortly that he's a Chitan is, as said by 70, Madam. He belongs to UNLF and extorts money. Let us comes to that. In the re-examination, he has said that I have received threat from Jitan. In the re-examination, Your Honor.
But the sad part is that in his cross-examination, he also said that he has not seen
No,
Jiten.
that- My lord, this, Your Honor, as I have produced that, one of that decision, yeah, Your Lordship has based this evidence in reality. It is not like a civil case or any other criminal case. My lord. Your Lordship will see how secret they were when they have been giving the evidence, my lord. That Your Lordship will see.
Yes.
And Your Lordship has seen, just for, where Your Lordship has seen that Peter 3 and 4 has gone to Myanmar, that is somewhere about that. And seen the last camp with all fatigue, army fatigue, etc., with arms and ammunition, etc., all the things. And with camps and all these things. And with revolutionary salute to the chairman, etc. Now, in all this matter, Bharat, can we expect a criminal case of this nature to be like any other? That Your Lordship will, I'm leaving to Your Lordship, Bharat, Your Lordship will just see. That cannot, and that cannot be, my submission, that cannot be like any other case, Bharat. So, people are shaking, Bharat. Even if they say, see, they will say, no, I'm not saying. That Your Lordship will. Then, Mala, below 34 Your Lordship will come. At page 261, now Your Lordship will find it, that is, pulling page, part 1, volume 2.
Part 1, volume
Volume 2.
2.
This is what? One FIR, Mala.
Yes.
PW 34 ballot 251. I'm working as sub-inspector police government of Manipur. I am now posted as DG control room in Impal. In the year 1996, I was posted at reserve line Impal based. It exhibit 86 is the affair. So arms act, etc. announcing. Lodge at so PS Impal HB 86 so and so are my signature. Of M. Ramsar Singh, which I identified. By the said FIR, three named accused person, namely Jiten Singh, then another Thoiba, accused number 18, were apprehended and 1.38 revolver number so and so and 4 rounds were seized from Jiten Singh and one M22 rifle bearing number so and so magazine, 4 rounds of recovered from accused number 18. Were recovered from the accused. The case was initially investigated by so and so. Thereafter, the case was entrusted to Ipol and so and so. However, I was transferred from so and so information. The arms recommendation which were recorded from the accused person were during arms operation. I have no idea whether the charge sheet against accused Jiten Singh was submitted before the court. I do not know. That's all. This is I leave this evidence to your lordship to take note of, my lord. Then PW 57, 8 page 333 of the same volume, my lord. My lord, he is the person, my lord. 50 is the person, bank manager, my lord, who has proved the account statement. All right, Rupa Singh. Bankers book of agents. That's so marketing. Yes. Yes. Uh, uh, Talking your lordship, my lord. These witness from the bank. Now, then your lordship will come to PW 67. Another witness from the previous model. FPS 362 model. I'm a permanent resident of so and so place during the period from 3rd May 1996 up to 20 July 1996. I was working as officer in charge of so and so in Palo. Does it? Malad, the same, I think, it's the same evidence of as of the same evidence, Malad, the sub same evidence supporting PW 34. What PW 34 has said, Malad, PW 67, Malad. What PW 34 has said, PW 67.
Yes.
It,
The purple, volume 1, part 2, volume 1, part 2, volume 1.
it,
this is all with regard to charge under section 20, my lord. Now, coming back to 121, my lord. Okay. There your lordship has been shown the list of officers, my lord, your lordship has seen. And I'm only referring to the list of officers, my lord. That is in part 2, volume 1, my lord, page 17. At serial number 10, my lord, serial number 7, my lord. He is Lieutenant Colonel G10. And your lordship has seen it number of times, but your lordship has gone. We'll try to see the admissibility, etc. Later on, but I'm just placing this.
His name it is with serial number,
Serial number 7, my lord.
Major.
No, Colonel, my lord. Colonel. At page 17,
Oh, acha, Lieutenant Colonel.
Lieutenant Colonel.
Yes.
Then your lordship will kindly see his photo at page 118 and that is exhibited exhibit 18. It is, I think, 18 by 18 by 9, I think. 9. Yeah. 18 by 9 at page 118. He appears as serial number 74. Now, these are the evidence against A10, my lord. Now, coming to 313 statement, my lord, your lords will come to question number 3, that is part 1, volume 1, part 1, volume 4, part 1, volume 4. part one, volume four, that page 760, I think it's 6. Yes, 758. It begins at 758. The relevant questions are question number 13. Question number 17. Question number 21 and 21. 30, I think. Question number 30 and 37.
Please come again, question number?
Question number?
Madam, question number 13, 15. 13, 15, then going to keep ahead. And 13, 14 also there, 14, 15, 16, 21, 30, 37, and
After 21, 30.
yes, 30, 30, 37, 41. That's when to deal.
Yes.
Now, Marot, judgment at paragraph only relevant. Activate 46. Oh, paragraph 46. 46. Then seven. Seventy 76. Judgment at paragraph 46. Other paragraphs I'm not relying, Madam. 46, 47. Inherited. It. Inherited. Account statement to put it. Any particular topic? One one five, 115. Cái trong cái đó macro là cái gì? Chuyện mà tìm. Đấy. Rồi. Cái cái thôi. Cái my lord, at paragraph 45 of the judgment, my lord, at page 970. Just one sentence, my lord, I will just paragraph 45 down below. His, it states about 115, exhibit 115, my lord.
Page number?
Page number 970. That is part 1, your
Yes, we got it.
volume 5. Forty-five. My lord. Paragraph 45, my lord, line about 5%. This further reinforced the prosecution case that the members of the university stayed in Guwahati and transported money till they were arrested. Exhibit 11514 was an attachment dealing about family maintenance for the month of September so and so. September so and so. Of account number 8, 9, 10, 11, 12, and the expenditure of inlet maintenance of accused of the accused person appears to be strong proof. Now, here you also will find an entry where at page and that is part 2, volume 1, at page 94, G10 names appear, my lord. September 7, 19,000. That's all.
Page number?
That is part 2, volume 1, page 94. From down below 1, 2, 3, 4, 5. Yes. 5. 19,000. He received an amount of rupees 90,000 from the UNLF fund. Then coming to paragraph 47 of the judgment, madam.
Now, what do you intend to show from page 92?
Reading paragraph 45 of the judgment, I intend to show that the observation of trial judge is correct because he referred to exhibit 13/66 where G10 accused number 10 names appear receiving 19,000 from the UNLF fund for their maintenance. That is only my submission. Has your lordship got page one? 94 is a page.
45 of 13/66
94.
reference.
94 is a page. 94.
Here you see,
To volume 1,
no, but where is the reference in page 45?
45. 45 your lords will down below, Mala. These further reinforce the prosecution case that the members of UNLF stayed in Guwahati and transported money till the.
That is okay. But where is the reference to link it with some evidence, with some exhibit? That's not there.
No, this is a judgment.
No,
This is a
no.
judgment.
You,
He
you see,
only-
either from one of the witnesses, you have to show that this is what is there. Because you see, link to that document evidence is not there. Link to any witness.
No, we'll have to go higher up, madam. He has discussed exhibit 115, we are coming to that. Your lordship wants that your lordship will find. Well, paragraph 41, your lordship will find. PW 84 is also stated that during investigation, email so and so is recovered through disclosure statement made by so and so were placed in the charge sheet. And during recording of the evidence, these are marked as exhibit 115 series. The February 84, the chief investigating officer of the case stated that email so and so record to disclosure A 18 to 9 and 19. Hey, your lordship got it. PW 41, PW, oh no, paragraph 41, 42, page 967.
Yes,
Page 967 of the judgment,
yes,
paragraph 41. PW 40, PW 84 also stated during the investigation, the email exhibit E1 to E101 as record through disclosure made by A18 and 19 were placed in the charge sheet. And during recording of evidence, these were marked as exhibit 115. 84 of the CIO of the case stated that email E1 to E101 record through the disclosure of A18 and 19 and exhibited as 115 series reveal the fact of regular communication between ULR leaders with and about other members of the outfit. It may be mentioned here that most of the emails and several communications, including several attachments, retrieved on the basis of disclosure of A18 and 19 were in Manipuri language, and these emails and attachments, which the prosecution investigation thought to be necessary and relevant, were translated to English. In this connection, paragraph 42, in this connection, Peter for 17 stated that as per instruction of CIO of the case, the email exhibit 115 were personally taken by him to Bangalore for translation from the Manipuri language to English. And one Asian professor who was well versed in Meitei language of Manipur translated his document to English, and the same were returned to NIN. The person who translated the email into English also issued a letter certificate, which was exhibited in Exhibit 185. On perusal of Exhibit 185, it appears that the identity of the person who certified the translation from Meitei to Meitei Manipuri to English to be correct and was kept secret, and he was cited as protected witness, though he was not examined by the prosecution in the court. It would be pertinent to mention here that the accused were all well versed with Meitei Manipuri language, the same way being their mother tongue. The English translation of the original emails relied upon by the prosecution were supplied to all the accused during the supply of copies to them, and hence it is evident that the accused were in possession of the copies of the English translation right from the beginning of the trial. Had the translation not been correct, the same would have been definitely pointed out by the defense. P.W. Severin was the only witness who was accused in this case regarding the translation of the email in question to English language. During cross-examination with the witness, they admitted that exit 185, where there was no specific mention of the person who translated the email into English. The witness, however, denied the defense suggestion that the contents of exhibit 185 were fabricated and manipulated. The witness also denied the suggestion that he was not present during the entire process. The defense, however, did not give any suggestion to the witness challenging the correctness of the English translation of the email exhibited as the 115 series. On perusal of the files containing exhibit 115 series, it was seen that the original communication in Manipuri language was followed by the respective English translation wherever necessary. It was therefore difficult to accept the defense proposition that the translated version of the emails were not part of record. Let me now briefly examine to what were the contents of the same of these emails. Attachment were retrieved through the voluntary disclosure of email ID and corresponding password of A18 and 19. Only they had the exclusive knowledge of this email ID and corresponding password, and their statement led to discovery of facts under section 27 of the Evidence Act. E1 to Exhibit 115 series contained contained the details of NIA taking over the investigation of the case, and the email was received in the email ID of A18 and 19. In the email, an apprehension surfaced that the center of bail was worried that all talks in the mobile phone might be retrieved by NIA. This in itself revealed that nature of such conversation. If retrieved, would link them to terrorism-related matters. However, such conversations on mobile phone were not retrieved by NIA. E4 Exhibit 1 contained the email exchange between A18 and 18 and A1 regarding errors of A15 along with A16. It appeared from Exhibit 11513 and Exhibit N A15 was under observation of the party E5 Exhibit 11515 mentioned about apprehension of A16 and also A15. Exhibit E6 Exhibit 11518 contained information regarding some financial transaction of UNLF. E11 Exhibit 1 contained communication regarding detention of A5, 7, 11, 13 under NSA. It also mentioned about possibility of jumping of bail by 6 and 14. E12 Exhibit 11553 was about promotion of 2 NCO cadre. E16 11573 was regarding treatment of accused Telemba, accused number 17, attachment E17 stroke 25, Exhibit 115123 mentioned about communication expenses of A5, E20 Exhibit 155 mentioned about release of A13, accused number 13 on bail. E21 115157 was mailed with an attachment in 3 pages. Exhibit 115, 159, 156, 164 made in letterhead of UNRF and signed by Chairman 19, Exhibit A19, Exhibit 115, 165, Exhibit 115, 168, and 170 are as in the letterhead of UNRF signed by accused number 19. Exhibit 115, 172 was communication about the arrest of accused E5, 17, 7, 11, 12, 13, 14, and 14. Exhibit 115 by 176 was a mail communication regarding arrest of A10, 11, 9, 8, 12, 13, 14. Exhibit 115 by 178 was another mail regarding arrest of 7, 8, 11, 12, 13. Exhibit 115, 184 contained attachment, and in one attachment, Exhibit 114 by 194, account statement of NEMSO for July 2010, and among others also mention about phone bills of A5 and A15. It will be pertinent to mention here that it was proved that A15 was president of NEMSO, and even defense did not deny the same. Exhibit 115 by 222 contain an attachment account of NEMSO for June 2010 and mention about transportation expenses of A5 and 15. Exhibit 115 by 328 and 330 contain accounts of NEMSO and about expenses incurred by A5 and A15. Exhibit 115 by 342 was an attachment of a mail in letterhead of UNRF written in Manipuri language in the name of A19. Exhibit 1155-346 was another attachment in regard to accounts of April 2010 of NEMSO, and also mentioned transportation of A5 and A15. The aforesaid mails were retrieved from mail of ID of used by in 18 and 19 on the basis of their voluntary discussion, which have already been discussed about.
Just a moment, ma'am. Mr. Das, this, while you were reading this statement, you referred to the protected witness who had done the translation. That document we are finding at page 1000, volume 4, part 2. Because you just now read that he was not examined, though he was not examined.
Page
Page 1000, volume 4, part 2. Now here in the top it is written protected witness 80. 80 is Asim Srivastav. He was examined, but in his evidence we don't find reference to 185. So who has proved this?
No, it was proved by 79. It was 79.
It's 79.
79, I think.
But in the document it is written PW 80.
Let me check it up, madam.
You prepare that list of witnesses also, their evidence also, because otherwise we will not be able to follow you.
Protected witness was marked as PW 80 in the charge sheet.
In the charge sheet, okay.
He was not examined.
He was not examined, okay. But then who proved this document?
That is. In another chart, we should have given madam.
PW 79, madam,
PW 79.
page 419. Part 1.
No, he's referred to exhibit 185, 1 by 13 are the statements. 185, Acha, 185 is the certificate. Okay. This was volume
Page
4.
420, madam.
Just a moment.
One eighty four, madam. 79. Page 100, 1000. Okay, Mariko.
Part two volume.
You come to CRPC 293.
Government scientific expert, he is a retired person. He does not fall within that. Which implement for specified qualities.
You see, there's only one exemption
Yes.
of document being proved when,
Sir.
if he's a,
Okay.
if a person comes within the definition of 293(4). Correct. This PW80, it doesn't fall within this.
PW 80.
Listed PW80 in the charge sheet. His certificate can't be proved by third person. Because you see, if you come to page 294, three, 294.3. 294.2 first, it says the court may, if it thinks fit, summon and examine any such expert. And 3 says where any such expert is summoned and is unable to attend personally, the court may, unless the court has expressly directed him to appear, depute an responsible officer. So therefore, if a scientific expert, say forensic expert can't come, he can send a deputy, which is permissible under 393, 293(3). But once you're this PW listed PW18 charge sheet does not fall within the definition of scientific expert, then
PW 80 claim to be protected with.
no, we are not saying that. You see, he may be protected, but protection itself does not absolve him to be examined by the court.
He may examine.
The court could have said that, okay, we are examining you and not disclosing your identity.
I'm sure.
That's what. So you see, if
Even though he is protected matter, without disclosing identity, he can be.
he can be examined.
Yes.
So
Yeah,
what we are saying is that your entire electronic evidence, although it's not the argument of either Mr. Mishra or Mr. Singh, but the fact remains under 293, if they are not exempted, their entire evidence is lost.
This,
Admissibility of the evidence itself will now become questionable
madam.
because the third party cannot
whether-
come and say,
Whether the only thing is, madam, yes, I understand that, madam. That is not legal. Now the question is, madam, whether this court in appeal, when this objection or any ground was not taken, can look into it. That is up to your lordship. But
no, don't throw the ball that way. You see, it's very simple. Because when it comes to the inadmissible document being accepted in evidence, it becomes a what you call a very essential element of perversity.
madam. Madam, that your lordship. Madam, can we close it today?
Yes.
Tomorrow I'll complete this paragraph, so.
Just a moment. This Jiten Singh is also over. Jiten Singh is also over.
No.
Something is left. Okay, okay.
What if 52 half an hour? So, I'll work one of, placing the evidence as well as, 330 Mara, that is all. But then my submission before.
You see, Mr. B. Prasad and Mr. Rashekar, counsel for the appellants are present. The submissions of Mr. D. K. Das, senior counsel. Along with that, also say Ms. L. Devi, counsel for respondent number 1 are present. The submission of Mr. D. K. Das, senior counsel, assisted by Mr. D. Bharadwaj, counsel for the responded to remains inconclusive. List as a part and matter. Give tomorrow's date 22. Yes. This you may take and then give a list later on.